Welcome viewer, this is a module on the elimination of racial discrimination under the subject International Human Rights Law. My name is Nizamuddin Ahmed Siddiqui. Now, the present lecture is intended to supplement the e-text on elimination of racial discrimination module for international human rights law. I will try to deal with some ideas that could not find space in the write-up. Since the write-up has dealt technically with the legal definition of racial discrimination, I will try to define it here in a more general tone. In the first part, I will try to cursorily take up caste system in India under this heading as well. The second part of my lecture is intended to look into the legal framework available under the international human rights law regime to address the issues of racial discrimination. For a better understanding, one can always go back to the e-text of the module. I shall start with the question, what is racial discrimination? On a more philosophical plane, race is a human construct which has usually found its manifestation in two forms, the biological construct and the cultural construct. These forms, which often define race, are not independent of each other. Rather, it is their dependency which has enabled the concept to perpetuate. The objective for such perpetuation is again a third construct, the political construct. So, what I am trying to say is that you have the biological construct and the cultural construct, on the basis of which you have certain aspirations which constitute the political construct, which would mean that race is defined on the basis of the biological characteristics of human beings. It is mixed with the culture and the environment in which he is living to get to a certain motive, and that motive is often political in nature. Let us take this from a judicial perspective. Take for instance the landmark US Supreme Court decision of 1896 in Plessy versus Ferguson, the citation of which is 163 US 537, wherein the question before the court was whether the states can constitutionally enact legislation requiring persons of different races to use separate but equal, I will repeat it again, separate but equal segregated facilities. The facts of the case were as follows. The 1890 Statute of Louisiana, now Louisiana is a state in the United States of America. The 1890 Statute of Louisiana required railway companies to provide equal but separate accommodations for passengers belonging to the white and colored races. This could be done either by providing two or more passenger coaches for each passenger train, or by dividing the passenger coaches by a partition so as to secure separate accommodations. So, we now have two ways in which they separated people. The first was to have different coaches for different people, that was based upon the color and the ethnicity, or dividing the same coach into two different compartments by putting a barrier in between, by dividing it in between. In the process, no person was to be permitted to occupy seats in coaches other than the ones assigned to them. It also provided for imposition of fines or imprisonment upon passengers insisting on going into a coach or compartment other than the one set aside for the race to which he or she belongs. Now, this is very similar to seats reserved for particular gender in today's circumstances, but this is different from it in the manner that if you sit on a lady's seat in a train or in a metro train, you will not be fined, but the seat is for a lady. However, under the 1890 Statute of Louisiana, you had to sit on the seat that was only for you, and if you sat on any other person's seat, which means a person belonging to any other ethnicity or color, you would be fined. And the officers had even the power to refuse to carry the train passengers, and the statute also exempted the railway company from liability for any such refusal, which means you even did not have the right to compensation in such circumstances if the railway authorities refused to carry you on such condition. The petitioner, in this case Plassey, was a citizen of the United States and a resident of the state of Louisiana. Now, in United States, you have a federal system where the states have laws which are different from the law of the center. So, here the state of Louisiana has a different set of laws which are very specific to that very state. Now, even though Plassey had a mixed descent, he was entitled to every recognition, right, privilege and immunity secured to the citizens of the United States of the white race. Plassey had the descent of black in him, in his blood, but even then, under the law of Louisiana, he was recognized as a white man. Now, on June 7, 1892, he engaged and paid for a first class passage on the East Louisiana Railway. He entered a passenger train and took possession of a vacant seat in a coach where passengers of the white race were accommodated. Now, he was already recognized under the law of Louisiana as a white person, but even then he was asked by the conductor to vacate the coach and occupy another seat in a coach assigned for persons not of the white race. When he refused to do so, he was, with the aid of a police officer, forcibly ejected from the coach and arrested. Now, this case is quite similar to what happened to Mahatma Gandhi in Africa. While on a journey from Durban to Pretoria, the conductor ordered him to leave the first class compartment and shift to the van compartment, as it was meant only for white people. He refused to go and was unceremoniously turned out of the carriage. There is another incident again of Mahatma Gandhi, when he was asked in a court of law to remove his turban. Now, he refused to remove his turban in the court of law before the European judge and went out of the court. So, these are some of the instances which depict the form of racial discrimination. Coming back to the case of Plassey, the US Supreme Court in Plassey observed that the separate but equal provision of private services mandated by the state government is constitutional. Now, here the state government was making it mandatory for private services companies to provide separate but equal provisions for different set of people. Separate compartments for different races was hence not held to be a violation of equality and hence valid. However, this case was overruled later in Brown versus Board of Education of Topeka, the citation of which is 347 US 483 within brackets 1954. The case is discussed further in the e-text of the present module. Now, we can also see the elements of racial discrimination, even though not so directly present, but indirectly in the prevailing caste system in India. The caste system in India has been a product of religious and cultural discourse. Even though at some point of time it represented the recognized hierarchies in the society, very soon it became associated with discrimination and exploitation that continued for more than 1,000 years. Since the early 1950s and 60s, the concept of race and hence discrimination based upon it attracted the attention of the people across the globe. A number of conventions were signed to contain and control such discrimination. In the meantime, there were also efforts to equate caste with race in the Indian context so as to give protection against discrimination on the basis of caste. However, this could not be achieved because there was a division among academics as to whether race can be equated with caste or not, and if race can be equated with caste, then the international conventions on race would become automatically applicable to caste. However, noted sociologists like Dipankar Gupta argued that caste and race cannot be equated for a number of reasons. For instance, since caste is not about descent, it cannot come under the purview of Article 1 of International Convention on Elimination of Racial Discrimination. Similarly, there is no phenotypical resemblance between the members of the same caste, which is much pronounced within a race. Now, to explain it further, the phenotypical resemblance means the resemblance in terms of physical characteristics. For example, you have people from Africa who look very different from people from Britain, or people from Scandinavian countries, they can be distinguished from people living in India. So now these are phenotypical differences, but these kind of differences, they are not existent in the caste system in India, and hence it was decided that caste should not be equated with race, even though there are debates existing even now. Now, the second question which I think is important and which I am going to deal with in this lecture is, after defining race and dealing with the various definitions of race and nature of race, the question is, what is the legal framework available against racial discrimination? We have a number of conventions. I will go in the chronological order. The first convention is the European Convention on Human Rights, 1950. Then you have the second convention, International Convention for the Elimination of All Forms of Racial Discrimination, 1965. The third convention is American Convention on Human Rights, 1969, which is also known as the Pact of San Jose. The fourth convention is the African Charter on Human and People's Rights, also known as the Banjul Charter of 1981. And the final convention is Inter-American Convention Against Racism 2013, which was signed on June of 6, 2013 and has not yet come into force. All of these conventions, barring the International Convention for the Elimination of all forms of racial discrimination and Inter-American Convention Against Racism, deal with the idea or the concept of racial discrimination in an indirect manner. However, these two conventions, they specifically deal with the issue of racial discrimination. One more thing to add here before we move on further. The Inter-American Convention Against Racism 2013 has got only 9 signatories out of 35, and till now, that is 8th of November 2014, there are no ratifications, which means that the convention is still not in force. Now, we will deal with these conventions one by one. With the specific conventions we will deal in detail, the other conventions we will deal with in general. First, the International Convention for the Elimination of All Forms of Racial Discrimination 1965. We have already discussed this convention in quite detail in the e-text of this module. There we have discussed the functioning of the Committee on Elimination of Racial Discrimination and the nature of cases which can be brought before it. But for illustrative purposes, we can discuss some of the decisions now, and we should discuss the lone case of racial discrimination before the International Court of Justice, that is Georgia versus Russian Federation, the citation of which is 2008 ICJ 140. Now, in this case, the submission by Georgia was that Russian Federation was engaged in acts of ethnic cleansing in its territory in complete violation of Articles 2, 3, 4, 5 and 6 of the Convention Against Racial Discrimination. The facts of the case are that during the period of conflict from 1991 to 2008, Russia was charged of committing human rights violations based in ethnicity. This is the reason why they are calling it as ethnic cleansing. A number of allegations were made by Georgia, including widespread and systematic discrimination against ethnic Georgian population during the armed conflicts, number 1. Number 2, denial of the rights of ethnic Georgian internally displaced persons. And number 3, launching of a war of aggression against Georgia on the basis of racial or ethnic discriminatory policies. Now, the case is of 2008 and it went before the ICJ, where ICJ held that it did not have jurisdiction under the convention to give a judgment on merits, which means that ICJ did not go into deciding the rights, liabilities and duties of the parties involved. What it said was that Article 22 of the convention, which is the Convention on Elimination of Racial Discrimination, requires the parties to attempt a negotiated settlement before proceeding to adjudication, which the parties did not resort to. So, in other words, what ICJ said was the parties should have tried to resolve the issue between themselves through negotiation, and if the negotiation would have failed, then they should have come before the International Court of Justice, because this is the procedure as laid down by the Convention on Racial Discrimination 1965. The second convention that we have is the European Convention on Human Rights 1950. Article 14 of the convention puts a prohibition on discrimination on a number of grounds, including race. Similarly, Article 1 of Protocol number 22 to the convention puts a general prohibition on discrimination as to the enjoyment of any right embodied therein on the ground of race, among others. There are a number of grounds on the basis of sex, ethnicity. Race is one of the grounds. Under the European Convention, the court is empowered to look into individual or group applications as well as interstate cases, the cases between the states. The jurisdiction is to be decided by the court itself, which is subject to the exhaustion of all the local remedies. Now, this is very similar to what ICJ recognized in the Russia case. Under the European Convention, you have to first go and resolve the issue under the municipal legal system as and between yourselves, and once you have exhausted all the remedies that are available under the municipal legal system, then only you should go before the European Court on Human Rights under the European Convention on Human Rights. As an illustration, we can discuss some cases, in fact two cases. The first is Aziz versus Cyprus, which was decided on 26th of June 2004. Now, in this case, there was a refusal to register the applicant on the electoral roll for parliamentary elections. Now, in every election, you have two things. You have an electoral roll, which is provided for people who can vote, and also the people whose names are there on the electoral roll can stand in elections. So, the electoral roll is serving two purposes, for the candidate and as well as for the electorate. Now, in the case of Aziz versus Cyprus, the applicant was denied the chance to register his name in the electoral roll, and he wanted to contest for parliamentary elections. The ground provided was that members of the Turkish Cypriot community could not be registered on the Greek Cypriot electoral roll. So, they had an electoral roll which was in ethnicity based upon Greek. However, the applicant was Turkish in his ethnicity, and since he was Turkish in his ethnicity, the authorities did not allow his name to be put on the list of people who belonged to Greek ethnicity. When the case went before the European Court, the court found it violative of Article 14 in conjunction with Article 3. Now, Article 3 talks about free elections of the convention. The second case that we can discuss in this regard is Timishev versus Russia. This was decided on 13th of December 2005. The European Court in this case observed that discrimination on account of inter alia, a person's ethnic origin, is a form of racial discrimination, which means that if you are discriminating a person on the basis of his descent, then it can be termed as racial discrimination. Also, once an applicant has shown that there has been a difference in treatment, it is for the government to show that the treatment was justified. So, the onus of proof and the burden of proof would now shift upon the government to prove that there was no discrimination on any ground whatsoever. Coming to the Inter-American Convention Against Racism 2013, as I already mentioned, it is not yet in force. Now, it defines racial discrimination as any distinction, exclusion, restriction or preference. These are 4 grounds which it provides: distinction, exclusion, restriction and preference. It has to be there in any area of public or private life, and the purpose or effect of such distinction should be, number 1, either to nullify, or number 2, to curtail what? The equal recognition, enjoyment or exercise of one or more human rights and fundamental freedoms recognized by the parties. So, we have a long list of gradients upon which the definition is based. The first is the rights and freedoms, they are to be recognized by the parties, and as to the enjoyment of only those rights, there should not be any distinction, exclusion, restriction or preference, and that all of these can be in public life or in private life. So, wherever they exist, that would be treated as a form of racial discrimination. Article 2 and 3 of the convention talk about the right to equality in the form of, number 1, equality under law, number 2, equal protection against racism and racial discrimination. Both of these can be enjoyed publicly or privately. Equality under law and equal protection against racism and racial discrimination can be enjoyed publicly or privately. And number 2, recognition, enjoyment, exercise and protection, they all can be enjoyed individually and collectively. Article 4 provides for the duties of the state to curb such activities which cause discrimination. Under Article 15, Clause 1, complaints can be made to Inter-American Commission on Human Rights by persons, number 1, number 2, groups of persons, and number 3, non-governmental entities. Number 4, the application can also be made by state parties, but then that is subject to agreement between the states. For example, if state A and state B both are members of Inter-American Convention Against Racism 2013 and they have agreed between themselves that in case of any violation of equality we can go, then only in that situation the one state can go against the other state for the violation of the provisions of the convention. Now, we have Article 15, Clause 4, which provides for the establishment of Inter-American Committee for the Elimination of Racism and Racial Discrimination. The state parties will have the duty to submit reports to the committee once the convention comes into force. So, the function of the Inter-American Committee for the Elimination of Racism and Racial Discrimination is recommendatory in nature and not binding. In the end, we can conclude that the recent developments show that there have been some positive steps taken at the international level to curb racial discrimination. However, the implementation machinery at every level still lacks the teeth. What do I mean by lacking the teeth? Lacking the teeth means you do not have the means to implement those provisions, and if a state is not able to implement those provisions, you do not have a machinery to punish or redress such discrimination. Even though you have that machinery under certain conventions, but generally there is not a very sound machinery which can address the issues of violation of race, which can address the issue of racial discrimination. Then again, lack of a proper definition of race is also creating a lot of problem. There are academics who argue that the term race should not be defined, and we should not enter into the debate as to what is race. The reason is, once we enter into defining the term race, we move away from the main issue, which is defining and limiting racial discrimination. Not only at international plane, but also at the domestic level, discrimination is a big problem. Even in India, we have discrimination which has become now a big problem without any foreseeable immediate solution. Now, that problem exists whether you equate caste with race or not. The only difference, if you equate caste with race, would be that once caste is equated with race, India would have obligation under the Convention on Racial Discrimination internationally. But then you will not be able to address the specific problems related to caste. However, if you do not put caste under the category of race, you do not have an international obligation to carry out. So, if you move in any manner, we have to do certain things to address the entire situation. And the final solution can be that one has to find solutions from within. From within means from within the individual, from within the community, and hence from within the society. Thank you very much.